am one of the attorneys here at CAR, and I am just going to do some introductions this afternoon. We're here, you're going to hear a great presentation on fair housing. It certainly is a topical subject these days, and while it has been for years, it's taken on some particular import, of course, during the last few months with a lot of activity in that arena. And because of that, we have our resident expert, although maybe he doesn't like to be called an expert, we have our resident attorney who has more knowledge than the rest of us on that subject, and that is Amanda Byun, who will be doing the presentation today. So why don't we at least hear from Amanda, and then I'll do some introductions.
Good afternoon, everyone.
All right, perfect, Amanda. I'm hearing you loud and clear, and hopefully everybody else is as well. Amanda, would you please, before you switch the slides, that's okay, we'll start with this. Either way, I just want to make sure everybody knows that this is our second Legal Live webinar of the month. We did one last week. The next one will not happen until next month. And next month, we are particularly pleased to announce on Tuesday, September 1st, we're going to be joined by the Commissioner of Real Estate, Doug McCauley, and some of his staff members as well, what we call a conversation with the DRE. And the Commissioner will be making some remarks, his staff will be making some remarks, but the most important part about next month's webinar is that the Commissioner has offered to address questions that CAR staff and members have. So if you have something that you're just dying to know, what does the Department of Real Estate think about your particular issue? Send it to us. You got a week, but don't wait a week. Send it to us right away. Send your questions to, right up there on your screen, to Danielle C. at car.org. We want to send all the questions in advance to the Department of Real Estate. We've had great sessions the last 3 years. We anticipate we're going to have another great session on September 1st. And then hopefully coming up in October is going to be the return of You Be the Judge. And that is our Legal Live webinar, where I talk about some real live cases that have made their way to the courts of appeal. Cases that make their way to the courts of appeal are usually difficult cases. They're usually hard to decide. The easy ones don't make it that far. The easy ones get settled. The easy ones get resolved at trial, and everybody knows that the winner is the winner and the loser is the loser, and there's no sense in proceeding after that. But the cases that go up to the Court of Appeal are often difficult, hard issues. I'm going to be bringing those issues to you and having you decide who's right and who's wrong, and then you can find out if you are on the right or the wrong side of the law. With everything going virtual this year, that may conflict with the CAR's Reimagine. If it does, we'll schedule for another date. But that's what's coming up for the Legal Live webinars, September 1st. Remember to send your questions to Danielle C. at car.org. We want to really impress Commissioner McCauley next month. Hopefully, again, we'll be seeing you in October. Amanda, before you go to the next slide, just want to remind everybody that these webinars are recorded, and you can find them, the past ones, and you'll find this one maybe as soon as this afternoon, but certainly by tomorrow, at car.org/risk management, and you'll look for the Legal Live webinar tab. So great way to not just learn about this topic or refresh yourself on this topic, to tell your friends, to tell your acquaintances, to tell your fellow realtors that there is a way that they too can learn, even if they were not available for today's session. And why don't we go to the next slide, Amanda? And here we go. So Amanda, that's it for me. Before we go, as usual, Amanda, in the background, we have Justin Murakawa, who will be doing his best to answer questions as you raise them on the line. And of course, we're going to be flagging questions for Amanda to raise at the end of her prepared remarks. That's all I have to say. Time for me to go on mute and to turn the mic over to Amanda Bjorn. Take it away, Amanda.
Thank you so much, Neil. Good afternoon, everyone. Thank you for joining me today. This afternoon, we're going to be talking about a topic that, as Neil pointed out, is very topical and also at times very difficult to discuss. But it is a hard conversation, but it is something we do have to have. So thank you again for joining me this afternoon. To kick off this presentation, I wanted to start with this new fair housing campaign by NAR. Accountability, Cultural Change, Training, or ACT. In light of recent events with the Black Lives Matters movement and undercover investigations exposing still prevalent racial discrimination in housing, NAR and CAR have recommitted themselves to promote equal access opportunity in housing for all. As the first part of this presentation will show, we as realtors have a lot to account for and to bring about cultural change through training such as this. So again, it's not just an ad campaign, it's up to us, the realtors, to bring about the changes that we need so everyone can have equal access to housing. So to begin, here is the chronological timeline of the expansion of equal protection rights in America and how that is intertwined with fair housing rights. For sake of time, I will only point out the highlighted portions, but if you are an amateur historian or political junkie like me, I think you'll appreciate the whole timeline to be reviewed at your leisure. So we start off 1776, Declaration of the Independence, where it was stated all men are created equal, but we're not actually. And it wasn't until 1866 when the Civil Rights Act granted citizenship and equal protection under the law to people of all races and colors, and granted Blacks right to own property and vote. In 1908, the National Association of Real Estate Board, now known as NAR, was formed, but its membership excluded Blacks and women from membership. So again, it was basically for white men only back then. In 1924, the NAR Code of Ethics that you may be familiar with had an actual specific requirement for racial steering. As a realtor, you had to make sure people of different races lived apart, separate, segregated. 1934, the Federal Housing Administration was formed, and they started redlining practices. So there's an old map of LA area. The red areas are called the red line areas, were basically relegated to minority neighborhoods where they were not giving out loans. 1947, due to the exclusion of membership from NAR, the NAREB realists were formed by Black real estate licensees to service their community. In 1950, NRA, now known as NAR, started making changes to the Code of Ethics, replacing the word race with character of property or use in the Article 34, which is of the Code of Ethics. In 1959, California passed the Unruh Civil Rights Act, which banned discrimination based on race, color, religion, national origin, or ancestry by businesses. 4 years later, California passed the Rumsford Fair Housing Act, which banned housing discrimination based on race, color, religion, national origin, or ancestry in private 5+ housing and government-funded housing. Just a year later, CAR sponsored Proposition 14, meant to overturn the Rumsford Act and the Unruh Civil Rights Act and amend the California Constitution. And it passed with overwhelming popular support. 2/3 of the population voted. And so in 1964, the fair housing laws that had just recently passed in California were repealed under this proposition. And in part, I just wanted to point out the language of the Constitution. It was changed to say that neither the state nor the agency thereof shall deny, limit, or abridge, directly or indirectly, the rights of any person who is willing or desires to sell, lease, or rent any part of his real property, to decline to sell, lease, or rent such property to such person or persons as he, in his absolute discretion, chooses. Now, the reason I point this out is because this argument is still being used in 2020. So I just wanted to point that out to you, that this was a Prop 14 that passed in 1964 to overturn the fair housing laws. However, just 2 years later, in 1966, California Supreme Court found that this Proposition 14 violated the 14th Amendment of the United States Constitution, which gave equal protection under the law to all races. And then the next year, the US Supreme Court affirmed that case. So Proposition 14 is now gone in California. In 1968, the Civil Rights Act, also known as the Fair Housing Act, passed after many years of bitter fighting, 7 days after the assassination of Martin Luther King Jr. And that brought on the federal fair housing law to all of America. And finally, in 1974, NAR Code of Ethics was finally changed. It adopted Article 10, which now prohibited housing discrimination by realtors. So as you can tell, there's been now a progression of laws and addition of protections, expanded protections, since the passing of the Fair Housing Act in 1968. And here's a list of all the new added classifications of protection and the expansion of protection, even up to July 2020, where we're looking, there may be now a chance that under the Fair Housing Act, which is the federal law, that sexual orientation may also become a protected classification. It isn't yet, but because of this recent case that came down in July, there's a greater hope that that may also be recognized under the federal law. So I talked briefly about the NAR Code of Ethics. Here is the progression of the change to the Code of Ethics. When it started in 1924, Article 34 read, a realtor should never be instrumental in introducing into a neighborhood a character of property or occupancy, members of any race or nationality, or any individuals whose presence will clearly be detrimental to property values in that neighborhood. In 1950, it was slightly changed. They dropped the word race and replaced it with just character of property or use. But still, the intent of the article remained, which was to segregate people of different races and religion and backgrounds. 1951, there was another slight modification to the Code of Ethics. They dropped the word should never to should not. So slightly lessened, it was from never to not. And as I pointed out earlier, it wasn't until 1974, 6 years after the passage of the Federal Fair Housing Act, that the final Code of Ethics, Article 10, as we are familiar with today, passed. And that read, realtors shall not deny equal professional services to any persons for reasons of race, creed, sex, or country of origin. Now, the current version of Article 10 is on the screen as well right now. It has expanded classifications for protection, but it's remained pretty steady for the last 45, 46 years.
So Amanda,
Yes.
this is that what you just showed us over the last few screens was really a great chronology of events. And I was looking through this and I was thinking, okay, realtors who are listening today most of them probably were not even in the business in 1974 when NAR created what's the equivalent of today's Article 10, which is really a non-discrimination article of the Code of Ethics. And so many of our members will be thinking, well, you know, ever since I've been here, there's been this positive policy. And what I really like about what you did over the last few screens is you showed people, well, there was a real progression, and it wasn't easy to get to this point. And I think it's important for members to understand history to prevent that history from coming back. And so those of you who are listening could think, you know, could just look back and say, this is a reminder, and it's a reminder of where we don't want to go again. So thank you, and I'll let you go on.
No, thank you, Neil, for that clarification. Yes, and that is part of the accountability for us to sort of look back into our history. Although many of these events happened in the 60s, they are still relevant today. And it's a good reminder for us to know our own history so we can be held accountable and make sure that the past isn't repeated today. So what are these fair housing laws that we've been talking about? Well, there's a lot, and that's one of the reasons why fair housing laws are complicated. As I mentioned briefly in the chronology, I'll describe briefly the laws that we're going to be talking about. And cumulatively, these laws are called the Fair Housing Laws. On the federal level, we have the Fair Housing Act. We have Section 504 of the Federal Rehabilitation Act of 1973, and we have the Federal Americans with Disabilities Act. On the state level, on the California state level, we have the Fair Employment and Housing Act, commonly known as FEHA. There's Unruh Civil Rights Act, also known as Unruh. California Disabled Persons Act, that's our version of ADA. And then California Ralph Civil Rights Act, that's California Hate Crime Act, I believe is sort of commonly known. And in addition to that, your local city and county may also have their own fair housing ordinances. So all cumulatively, there are a lot of different laws are sort of combined called the fair housing laws. And there are a lot of details, ins and outs. There are a little bit of slight differences, but we're gonna try to look at them as a one sort of cumulative law, so it'll be easier for you to follow. Okay, so discrimination. So who are the protected classes and or characteristics? So under FEHA, the federal law, they only actually list 7 characteristics. FEHA and Unruh combined, they have 24. So California law is much more broader. Some of the big ones are color, race, religion, sex and gender, national origin, ancestry, familial status, which is basically families with kids under the age of 18, handicap or disability, source of income. Section 8 vouchers was recently added starting January 1st, 2020 under California law. Military or veteran status was also newly added in 2020. And this is interesting, perceived membership to or association with protected groups or persons. So if, let's say, I have a friend who's Black and my landlord is discriminating against me, doesn't want my Black friend visiting me at my apartment, well, that's an association with a protected person. Or if someone mistakenly thinks you are of Jewish background or of some national origin, and that was a mistake, they perceived membership in a protected characteristics and thus discriminated against you, you are still protected, even if you were not in fact in that protected characteristic or class. Under Unruh, even if you're not listed under one of these characteristics, anything that's considered arbitrary or unreasonable discrimination may also be a violation of the law. And just as an explanation, disability or handicap under the federal law can be both physical or mental illness. And mental illness comes up often, and we'll discuss it more in detail later, in landlord-tenant situation with emotional support animals. So those are the people or classes that are protected. So what are you not supposed to do? Housing providers. Housing providers are landlords, sub-landlords, owners, real estate licensees, shall not discriminate by treating unequally members of the protected class in housing. So what is a prohibited act? Some common ones are, and we'll discuss more of these in detail later on in the presentation. Denying or making unavailable sale or rental opportunity, failing to show, including steering, offering unequal terms, providing different treatments, advertising or making statements that indicate limitation, preference, or restrictions based on protected status, inquiring about a protected status, and refusing a request for reasonable accommodation to rules or policy to accommodate a disability. So discrimination can fall into two different categories, direct versus indirect. Direct is when you have a discriminatory treatment. It's as a direct statement or action and this used to be very explicit and overt. And that changed with the passage of the Fair Housing Act in 1968. They were very easy to identify in the past. However, in the modern times, direct discrimination has become more subtle and coded, so much harder for someone to identify as discriminatory. However, actual malice is not a requirement. You can maybe not realize you're discriminating, but if you intended to do that act, it's still illegal under the fair housing laws. So what are examples of explicit and overt discrimination? Under familial status, if you put in advertising, no kids, that's explicit and overt. Source of income. If a landlord tells a prospective tenant that they do not accept Section 8, which is now a protected characteristic, that's an overt discrimination. In the past, we had redlining, which was institutionalized racial segregation. And we also had racially restrictive covenants, CC&Rs. That went away, and examples of that were things like language in the CC&Rs that said only Caucasians, no Negroes or of people of Mongolian race. That went away, all of that went away with the passage of the 1968 Fair Housing Act. So,
Amanda?
Yes.
Would you mind going back to the previous screen? I have a question for you.
Okay.
So, there you go. Perfect. So I'm curious whether in that first segment you said actual malice is not required, but I'm wondering about a person's intent. So, for example, in your second point about explicit and overt acts, that the first bullet says, as an example, for example, no children in the rental ad. Now, maybe somebody's intent is actually to look out. So, for example, a person has a house, there's a pool, and maybe it's an older pool, so maybe it was built before there was legal requirements to have fencing around it. So maybe the owner is concerned for somebody with children that the children might be injured. Would somebody's reasoning matter in a situation like that?
Not for that, no. That would be considered direct discrimination if you intended to not rent to a family with kids because you deemed them to, for their own interest, you're putting out for their safety. That's not something for a housing provider to discern. That's something for the actual, proposed occupant, whether it's a buyer or tenant, to decide. And we're going to go into that a little bit later
Right,
under landlord-tenant.
Great, thank you.
Thank you. Okay, so Many of you may have heard this. There was a Newsday 3-year investigation, undercover investigation that was done in Long Island, New York. That came out November 2019. And basically, it was an, oh, excuse me. It was an eye-opening event where prevalence of coded and subtle racism was found in Long Island with the real estate industry. Testing was conducted with actors of various racial backgrounds.
Amanda, can
yes.
you go back a screen, I think?
Oh, I'm sorry.
Sorry.
Why is this not going back? Oh, here we go.
There you go. Thank you.
Yes. So what happened, they did a 3-year undercover investigation. They sent actors of various backgrounds to various different realtors asking for similar requirements, similar property price range, property type, location, and they sent white tester and then a person of color to see how they were treated differently, if at all. And the results were extremely surprising. They found that 19% of Asian American testers, 49% of Latinx testers, and 48% of Black testers were treated differently than the white testers that were paired with them. Basically, what they were trying to see if there was going to be racial steering. Racial steering is influencing a prospective buyer's choice in housing by failing to show or failing to provide or volunteer information on the account of the person's race or the racial composition of the neighborhood in which the property is located. So some of the examples they found were that to a white tester, a realtor would tell the white tester, you know, there's gang activity in this neighborhood. It's a true statement, there are gang activities, but that kind of same information wasn't shared with the Black tester. To a white tester, a realtor would say, you know, this neighborhood is mixed, there are people from Ghana, it may not be safe. Such concerns were not shared with the Black tester. Another example, a white tester and a Hispanic tester asked for a similar type of property within a certain distance from a neighborhood. White tester was primarily shown properties only in predominantly white neighborhoods versus a Hispanic tester who was shown properties in the mixed neighborhood, and a white tester was not shown properties in the mixed neighborhood. So that's what they found, very prevalent examples of racial steering in Long Island, New York. So what does that all mean for us? It's just to be aware in sales, what a listing agent or a seller should not, shall not do. You should not or shall not deny or make unavailable sale of a property due to someone's protected characteristics. So an example would be, if you receive a buyer love letter or see the name of the buyer or have some kind of a personal interaction, maybe you met the buyer at a showing that identifies the buyer's race or other protected characteristics, and a seller rejects the offer based on that characteristic, that is illegal under fair housing laws. It is also illegal to provide unequal treatment. Examples of unequal treatment is refusing to show a property to a prospective buyer, or even refusing to respond to inquiries about a prospective buyer. Offering unequal terms. Examples of that would be, you realize the buyer is of a certain race, and so you ask for a higher earnest money deposit, or shorter contingency time frame, or require more stringent pre-qualification. Those are all offering less favorable terms to a buyer. Now, it could be the reverse. You could say, oh, I like you, I'm what, well, not say that, but maybe think subconsciously, you are like me, I'm white, you're white, and I really like you and I want you to buy my house, so I'm gonna give you a better offer term. That could also happen, so offering different terms, not just unequal terms, could also be an example of discrimination. Making statements or advertising a preference, limitations, or restrictions based on protected characteristics. Now, again, with the Fair Housing Act of 1968, more overt examples of that have gone away. But certainly if you make references in quoted terms, as they did in Long Island, about racial composition of the neighborhood, that is showing preference. That's a statement about why you should not maybe live in this neighborhood because of the racial composition. You also should not be inquiring about the protected characteristics of a buyer. So do not ask about, a seller should never ask buyer to submit a letter or a picture, as I've been told some sellers in this very tight inventory market are saying, I want to choose my buyer. I want to know who they are. I want to know more personal things about them. I want them to submit a picture. I want them to submit a letter introducing themselves. You're opening yourself up for a lot of liability. You should not be choosing someone based on those kind of characteristics. A buyer should be chosen on the financials of what they're offering and the deal terms they're offering. And this applies for the listing agent. A listing agent shall not induce panic selling or cause blockbusting. That refers to a listing agent going to a seller, and getting them to give them a listing, telling them, some people of certain races or religion are moving into this neighborhood. Maybe, and property values will be dropping because of that. So why don't you get out while you can and move to a safer neighborhood? So that is a specific prohibition against listing agents and real estate licensees. Not so on the sellers, but on the agents themselves. What issues should buyers and buyer's agents should be aware of? Well, I just do want to make it clear, fair housing laws do not prohibit a buyer from choosing the type of neighborhood they wish to reside in. For example, if an Orthodox Jewish buyer requires a home within walking distance to a synagogue, they can tell their realtor that information. And a realtor, once the client tells them which synagogue and what distance is comfortable for them to be a walking distance, can figure out the parameter and show them properties within that neighborhood. That is perfectly legal, perfectly acceptable. A buyer should be able to choose a neighborhood they reside in. It's just the real estate licensee cannot tell a buyer which neighborhood they should be living in. It should come from the buyer. But a buyer's agent should not provide unequal treatment. As we saw in the expose in Newsday, you should not be giving differing information to buyers because of their race, their background, or showing them different property selections in different neighborhoods. They should not steer buyers away from certain neighborhoods based on, again, the buyer's race or the racial composition of the neighborhood they're looking at. Again, that is all very illegal under the fair housing laws. So we've just had a discussion about issues in sales. How about in rentals? There was another investigation, this time in Boston, and this tested the rental market. In this undercover investigation, they used white testers and black testers with names commonly associated with their race. For example, Jamal, Leroy, Aisha, Ebony were used for black testers. Brad, Todd, Ann, Carrie were used for white testers. They also tested for discrimination against Section 8 voucher holders, and they found extremely overt and high instances of discrimination that was regardless of race. So for this discussion, we're going to just look at the racial treatment of non-voucher holder cases. They found, just based on the names alone, that 80% of people with white names versus 48% of people with black names got showing appointments for rentals. So that's a 32% differential in getting an appointment based on someone's name alone. In-person interaction, however, the treatment for the white versus black testers were pretty even, which is good. They were greeted properly, handshakes, courtesy titles, introductions, all of that were pretty on par, which is good news. Okay, let's see. Okay, however, this is where we notice additional significant differences. For white testers, the first column, they offered 40% of them financial or non-financial incentives versus only 8% of black testers. For white testers, they offered negative comments 13% of the time, 8% of the time for black testers. Positive comments, 58% for white testers versus 33% for black testers. And then follow up, asking them, following up with the applicants to see if they're interested. 48% for white testers, 29% for black testers. So overall, 71% of black testers experienced discriminatory treatment in the rental market. So what are the takeaways? You may say, well, this happened in New York, this happened in Boston, we're in California. You know, these are things that happen on the East Coast. We don't know currently if there is an ongoing undercover investigation similar to the ones that happen on the East Coast in California. I do have it on good authority that DFEH will be starting some sort of testing later on this year. So these lessons that we learn from New York and Boston are very important for our realtors in California to understand and realize that these are, many of them may be unconsciously being committed, but these are things that are still illegal and you need to be aware of and be cognizant if you also practice in similar manner that you will and can get into trouble in California. So how do you avoid all of these? USA Today says your local high school is the #1 high school in all of America or all of California. You can cite that. That is fine. But don't use your own subjective descriptions. Number 4, share same neighborhood information with everyone. This is a problem that they ran into in New York. They would share different information with black testers versus white testers. If you're gonna tell a client about a dangerous neighborhood, tell all your clients about that. Everyone's entitled to the same information. Number 5, don't impose your own judgment for selection of property or neighborhood. Again, tip number 1, let your client direct the property search. And again, don't substitute your own subjective ideas about what neighborhood they may feel more comfortable in. That is something for the client to decide, not for you.
Amanda, I've got a question for you.
Yes.
I'm going back to the last screen, and there may not be an answer for this. But so many people are concerned about school, especially people who are living with children or expect to have children. oftentimes school districts will publish statistics on scores. Is
Yes.
that something that you think can be disclosed, or is that coded or buzzwords as well?
So what NAR has advised is that realtors cite, objective third parties. If your school district, and I know that California, statewide, there's statistics on various different benchmarks for school performance and grade performance and whatnot that the state publishes. Provide those kind of resources to your client. Obviously, school districts, how well a school district does affects property value. And if you have kids of certain age who may be going to a local high school or elementary school, you are interested in the type of school they might want to go. And that's the prerogative for the buyer to investigate. But an agent should be careful in directing clients with their own subjective knowledge. Again, you can provide them the resources that's objective, where they can get that kind of information if it is important for the client to choose what kind of neighborhood they live in.
So maybe if the client asks you, you could say, here's the resource page that has these studies
Exactly.
or these statistics available. Okay,
Yes.
great, thank you.
Tip number 6, use a blind selection process. And so this goes for a landlord or seller. Again, this is a bit controversial for me to say, but if you're a seller, do not accept buyer love letters, please. Do not, nothing in that letter should be relevant in your selection of a prospective buyer. For a landlord, you should always practice first in, first out. The first completed application should be the first one who's bidded for qualification. You should not select from a pool of application, because at that point, then you are putting your unconscious subjective requirements that are not necessary into providing equal housing opportunity for all. Number 7, treat everyone with same professional courtesy. Return inquiry calls. As we saw in Boston, people with Black names were 32% of the time were less likely to get a showing appointment. That's pretty glaring discrimination. Please return all inquiry calls. Respectfully address people. If you call them Mr. or Ms. or by their first name, please do so. Be courteous. Share same information with all your clients. If they say they're interested in neighborhood X, anyone who says they're interested in neighborhood X, share that information. Don't decide yourself, oh, this potential buyer is 80 years old. They don't need to know about this aspect of the neighborhood, or, oh, this buyer has kids, so they don't need to know about this other aspect. It's not for you as the licensee to decide what information is important for them or not. Provide all same information to all buyers. And offer assistance to everyone equally. Follow up with everyone. Number 8, this seems pretty clear. Offer same terms and privileges. Don't offer a better deal to someone else because you like them better. Well, there's nothing wrong with liking someone better, but if you're offering someone because subconsciously you identify with them more and offer them better terms, that can be illegal if based on protected characteristics. Review all advertisements. And please don't seek any information to family makeup. Don't ask tenants or buyers about kids, if they have kids, how many kids they have, what age are the kids. You may think you're being friendly, but you are asking a protected characteristic that really you should not be. If they volunteer that information, that's fine, but you as a real estate licensee should not be seeking that information.
Amanda, before
Yes.
you go on,
Yes.
we had a question before that seemed related to this one, as well as maybe to item number 6 that you brought up. And that is, what if an owner wants to differentiate a buyer based on whether the buyer is a developer or will be an occupant owner? Do you have any thoughts about that?
Well, so that's a very good question. There is preference in some type of sales of single family homes where preference is given to owner occupied buyers versus investor buyers. And that hasn't really been found to be discriminatory. Whether you're buying for business or for personal use is not a protected characteristics, and is not a substitute for a discrimination against a protected characteristics. Now, if that distinction is deemed to be arbitrary or unreasonable, then that could still become an illegal discrimination. But making a distinction between a single family residence, an owner occupied buyer who's going to move into the house and live in the house versus an investor who might, flip it or build a giant McMansion on the small lot, that would be considered an okay distinction, unless there's some other hidden reason behind the distinction.
And you would not want to go one step further and say, not only do I want to sell to an owner occupant, I want to sell to an owner occupant that's married, or an owner occupant that has children, or an occupant that has a family. You don't want to go that far.
Right, definitely. You're then clearly talking about protected characteristics.
All right, thank you. I'll let you go on. And Amanda, I know you've got a lot of screens, landlord, tenant, and we're at 2:17, so I'm going to ask you to try to cover as much as you can.
Okay, so just to go a little bit quicker, number 10, you have to be conscious about unconscious bias. We're human beings. We all have unconscious bias. We have identifications with people who look similar to us. And we just have to be cognizant that that exists. And if you're aware that exists, then you'll be more careful next time in practicing unconscious bias. Number 11, ignorance of the law or following the instruction of a seller client is not a defense to fair housing violation. You cannot say, well, I didn't mean to violate the fair housing law, but my seller or landlord told me not to rent to a family with kids. Or I didn't know that was illegal. That's not a defense to violations of fair housing law. And number 12, this is we're learning, everyone's learning. And if you do make a mistake, we are all going to make mistakes, turn it into a learning opportunity. So it's best to address it and realize what happened, and so you recognize that it doesn't happen again. As we said, with our past, with our actions of fighting the fair housing laws, we know what happened in the past. Now those are learning opportunities for us in the today, in the present, so we don't make those same mistakes again. Okay, so I'm gonna just hit some rental issues that are not just race related, emotional support animals, and Section 8. And let's go into that a little bit more. So disability is actually the #1 topic for discrimination in California. And typically they relate to assistance animals, or better known as emotional support animals, ASAs. What the law basically says is you cannot deny a reasonable accommodation request to keep an animal for persons with disability to afford equal opportunity to use and enjoy a dwelling. So ESAs, what are they? They're animals that are not trained to perform any tasks. They're not seeing eye dogs. Those are service animals. ESAs are not service animals. Their presence in the life of the disabled person improves the condition or alleviates a symptom of a disability. That's what they do. Being a mere companion pet makes the person feel better, essentially. What can a housing provider ask for, or a landlord ask for, if a tenant says they have an emotional support animal? They can provide an online certificate from a medical professional. So this has to be from an actual medical professional if it's going to be an online certificate. Or if it's not an online certificate, it can also be a written verification from a reliable third party in a position to know. Again, in this third party in position to know often are medical professionals, maybe a therapist. But again, the person has to know the condition of the disability and identify how that person is going to be aided in their condition by having this animal reside with them. whenever your request is made, you have to engage in an interactive process. That means you have to have a dialogue. You cannot just say no. You have to have a dialogue. And even if a small, very narrow exceptions may apply, you still have to have a dialogue. And what are the narrow grounds for denial? If it's an undue financial or administrative burden on the landlord, that could be potential reason for denial. If the animal poses a direct threat to the health or safety of others, if it's actually a known vicious animal, not just a dangerous breed, but this dog last month bit a person, that is a vicious animal you can deny, but not because they're just a pit bull. Or they pose a threat or potential cause for substantial damage to property. Again, if this dog, this particular animal, last month tore up the backyard in the property they were prior residents of, that would be evidence of this animal damaging real property, not again because it's a pit bull or Doberman Shepherd or large dog. What are the prohibited practices? You cannot have blanket advertising or statement bans, like no pets without a disclaimer. You don't want to discourage someone with a service or assistance animal from applying because they just saw the sign, no pets. You should not give unequal treatment. Examples of unequal treatment may be, excuse me, citing just the emotional support animal for rule violations, or pushing an application down the list of potential tenant applicants because they noted that they have a service animal or emotional support animal. You also cannot provide unequal terms. That means you cannot charge higher rent or security deposit, such as pet deposit, because they have an emotional support animal. That's illegal. And you cannot inquire about the medical condition. If someone says they have a disability, you cannot ask what the disability is. That is protected under health privacy laws. Another type of issue to be aware of is source of income, Section 8. This is a new addition to the law in California starting January 1st, 2020. The law basically says that you have to treat paid income from government subsidies, alimonies, or Social Security the same as earned income. If for government subsidies, financial qualifications must be based on the tenant's portion of the rent only. So if a tenant is getting Section 8 voucher and Section 8 is paying 70% of the rent and the tenant is paying 30%, your income qualification must be based on that 30%. So as an example, if the rent is $1,000, the tenant portion is $300. If your income qualification is 3 times, that'll be $900. Prohibited practices include, again, no blanket advertising or statements such as no Section 8. That's a no-no. No unequal treatment. Requiring an additional guarantor or requiring more stringent application process because, again, they are a Section 8 voucher holder. And you may not also offer unequal terms like trying to charge a higher rent or security deposit, or allowing them fewer privileges in a complex like no use of pools or gyms because, again, the tenant themselves are paying less for their own portion of the rent. So we've just discussed examples of direct discrimination. The next two we're going to talk about are what are called indirect or disparate impact discrimination. These
Amanda?
Yes.
Amanda?
Yes.
I just want you to let you know that we have a couple of questions that are generic questions for everybody that we've been saving. So I want to make sure we've got time to cover them as well.
Okay, so I'll try to get through this in 2 minutes. There are facially neutral policies that have an indirect or disproportionate impact on a protected group. So you may not have any intention of discriminating against a protected class, but the action result ends up in discriminatory impact on a protected class. And so these are not overt. And so the 2 examples we're gonna discuss are use of criminal history. California law says a landlord does have a legitimate interest in protecting safety of persons and property, but must do so in a manner that does not disproportionately affect people of color. So how do you do that? So you are allowed to review criminal background history on tenant applications. However, you have to follow very clear guidelines. You can only look at criminal history after a tenant has passed financial and other screening criteria. You may only look at relevant and directly related conviction records. No arrest records may be looked at, and the maximum look-back period is 7 years. The report will not show anything beyond 7 years unless it's related to Megan's Law database. But actual look-back period may be even shorter than 7 years. And if you find that there is a relevant conviction, related conviction, you must give the applicant an opportunity to respond and provide mitigating circumstances before you reject. And if you're going to reject for any reason, please consult with an attorney before you do so. Prohibited practices include no blanket advertisement or statement that says no felony. You may not have unequal treatment, like accepting a white applicant over a black applicant with the same conviction history, or pushing applications to the bottom of a list. And also, again, no unequal treatment, higher rent or security deposit. One last thing, familial status occupancy limits. The law says families with kids under the age of 18 are protected, except for legally compliant senior communities. You may have heard of the 2+1 per bedroom rule. That's not a black and white rule. It depends on the size and the configuration of the unit. So for instance, if you have a 1,200 square foot 3-bedroom condo versus a 2,400 square foot bedroom house, more people can live in the 2,400 square foot house than in the 12-bedroom, 1,200 square foot condo. So size matters, configuration of the unit matters. It's not a strict 2+1 room. More than, was it 7 people can live in the 2,400 square foot house. Prohibitions, no blanket rules, things like maximum 2 people or no kids, no inquiry into family makeup, age of kids, number of kids. Don't steer kids or families into certain sections or units. Like if you're a property manager of a complex and you see a family with kids, don't not show them upper units or show them only ground floor units. That's not for you to decide. It's for the tenant to say, I request a ground floor unit. It's not for you to decide. Don't provide unequal treatment, like citing parents with kids for noise violations only, and also no unequal treatment terms, higher security deposit, or fewer privileges because of the kids. And if you had issues of housing violation, fair housing law violation, here are the places where you can file a complaint with the federal HUD, with state DFEH. You can also find your local Fair Housing Council office. They're free nonprofit service. Against the licensee, you can file a complaint with DRE or with the local association of realtors. And final thoughts. Hopefully this session acted as a sort of a part accountability, cultural change, and training for all of us. It's a very difficult topic, obviously, but we have to realize we have to talk about them so we can continue our training, so we can bring about the changes we need to bring. And here's some summary of the laws that I talked about, a little bit more in detail, just in case anyone's interested: California law, federal law, and finally resources. All the things I've talked about, I just touched superficially. More in-depth discussions are in the Q&As and the quick guides. All the links are on this page, resources page. I think I have 2 minutes left, Neil, if you have questions.
Well, we do have some questions. I'm glad you're on this slide. It's the perfect slide. So before we get to a few questions, just want to remind everybody, first of all, there is a great quick guide on emotional support animals. How you get to the quick guides, car.org/risk management/quick guides. There's also a very good legal Q&A on Section 8 and source of income discrimination that you touched upon. Same thing, car.org/risk management, but you would type in Q&A, of course, instead of typing in quick guides. Okay, let me ask 3 questions. Hopefully our listeners will stay around to hear your answers.
All right, go ahead.
Okay, one is, if you have a lease and you name particular occupants, the example here is you name 4 occupants, and then a fifth occupant comes, are you allowed to charge extra for additional occupant? What if the new occupant is somebody's additional child that happens after they've already rented the property?
So that's a very good question, and there's not a simple answer, unfortunately. Under certain local rent control laws, like Los Angeles rent control laws, there is a provision for increasing rent if you have an additional person being added to the lease. And that's a specific provision under rent control. And presumption is the rent is already under market, so a tenant can be charged a little extra per the ordinance. But if you're not under a local rent control that allows that as a general matter, if it's a child under the age of 18, no, you cannot charge additional. If it's another adult that's moving in, I would say no, you cannot charge additional, because if you look at the 2+1 rule, it's again a rule of thumb. If you have a 2-bedroom condo, let's say, and you have 4 people living there, and a 5th person wants to join in, they're still within that 2+1 rule. You can't say it's over the occupancy limit. So if you couldn't deny 5 persons wanting to live in a 2-bedroom when they apply, can you not say, well, 5 persons is too much later on? So because of that, if it's not under local rent control, I say it's a risk to charge more, and I advise not to do that.
Okay, so thank you. And it is a difficult issue, and you should certainly seek advice if something like that happens to you and you're the housing provider. Okay, I have 2 other questions I wanted to bring up. One is, you had talked about reasonable accommodations for a person with a disability. Mm-hmm. Can you distinguish, if there is a distinction, between reasonable modifications to a physical structure? Maybe somebody needs wider doorways or needs to have the light switches lowered, for example. Can you distinguish if there's a distinction between reasonable modifications and reasonable accommodation?
Yes, so those are 2 separate things. They're both protected under FEHA, under California law, and also fair housing law as well. For request for reasonable modification by a tenant with a disability, that is at the cost of the tenant. The landlord just has to give permission to allow the modification to occur. And again, it's at the cost of the tenant, whereas for reasonable accommodation for, let's say, having a emotional support animal, if the landlord has some additional costs associated with that, let's say their homeowner's insurance is going to go up by a little bit because of that, that is a cost, unless it's exorbitant and an undue financial burden on the owner, that is a cost that the owner would have to bear. So that there's a distinction in that.
Another question, I see Justin put one in the chat that we'll address too. This is a difficult question because we're dealing with difficult issues. And past discrimination, there's some evidence that it's led to wealth disparities, in this country and in California. Is CAR doing anything to try to address that at the current time? Are you aware of anything like that?
That is a very excellent question. So many of you may not be aware, we're all working from home these days due to COVID, and we have weekly town halls. And this is a common topic we've been talking about. So there are many proposals that are being discussed at the director level about what steps CAR can take to, assist with affordability, with access. So there are many different aspects that CAR is investigating, and more information about what our plans are to promote that should be coming out in the next, few months, hopefully sooner than later. But there are a lot of different things being studied and followed through on right now.
Okay, so our listeners basically need to just stay tuned, because there will be probably some announcements from CAR in the not too distant future.
Yes.
Okay, and the last question that we have here, and I want to try to trim it down a little bit. But the issue is, if there's a rental that has a disabled adult, should the disabled adult be treated as any other adult, or maybe as a financially responsible occupant, similar to a minor? A little bit of an awkward question, but maybe you can understand that and provide some advice.
Well, that depends. I mean, so our general rule is, you should collect a tenant application from any adult, anyone who's over the age of 18 who's going to reside there. It may be there's, a mother and an adult child who's, let's say, mentally disabled and does not work, does not have a source of income or credit. And the mother may say, well, my child is over the age of 18, but will not be contributing financially to the rent. I would ask that you make my child an occupant. Please, such a parent could potentially ask for a reasonable accommodation from a landlord's normal procedure of collecting a rental application from all adults over the age of 18 who's going to reside in the property due to a disability. And that would not be a hardship for a landlord to accommodate that, especially if the mother is the main supporter, financial supporter.
Okay, great. Thank you, Amanda. Is there another slide that you have, or was the resources the last page?
I believe just a reminder about all things coming up, and please call us if we didn't get to any of your questions at the legal hotline, 213-739-8282.
And by the way, I happen to have listened to the most recent podcast. I listened to it this morning. So for those of you who have contingent sales, if you use the COP form, contingency for the sale of buyer's property, it's a difficult form, but Jana and Dana did a marvelous job really explaining it paragraph by paragraph. So those who have not listened to podcasts before, really, you want to listen to this most recent podcast from Jana and Dana, and you have the site there about where to file, where to get it. Again, car.org, risk management, / in this case, go to podcast. Thank you so much, Amanda. Thank you, Justin. Thank you, all of our listeners today. And we hope to see you next month. Again, if you have questions for the real estate commissioners, remember to send them in, Danielle C. at car.org. See everybody next month. Bye.
Thank you, everyone. Have a great afternoon. Bye-bye.